My name is John Bowman, and I have the distinct pleasure and privilege to serve as the President and Chief Executive Officer of North Island College. And on behalf of everyone at NIC, I want to welcome you here this evening to our Comox Valley campus. And I want to begin by acknowledging that the campus and our gathering tonight is on the traditional territory of the Comox First Nation. And I'm very proud of the fact that NIC has a very positive and close working relationship with all of our First Nations in the North Island region. I also want to extend a special North Island College welcome to our special guest, the Honourable Ross Green, who's going to be our speaker tonight. And I want to say by way of introduction that this evening I'm becoming a little less dangerous. I've been joking that as the new president of North Island College, I know a little bit about a lot of things, but not a lot about anything in particular. So the old adage is that a little bit of knowledge is a dangerous thing. And tonight I become a little less dangerous with respect to the Community Justice Center and our criminology program and our partnership between the college and the Community Justice Center, which I understand is a very positive and important connection that the college has with our community, and evidenced by this being the third annual Iona Campagnolo Lecture series event. So I want to say how excited and positive the college is about our relationship with the Justice Center and how much we value our collaboration around this particular event. Also about the success and growing appeal that our criminology program has, and certainly this lecture series is helping to raise the awareness in the community about the college's programming related to justice and criminology. Looking ahead, this is the third annual. We're looking forward to next year, and we're going to hear a little bit later on some of the future speakers that are planned for this series, and we're very excited about the whole process going forward. I think, just to end, I want to welcome and express our appreciation to the Chief Administrator, Bruce, who's going to take over the microphone momentarily. We're really fortunate, I think. I'm told that the Justice Center is really a leader provincially and nationally and has been doing some really creative things, and it's exciting for the college to be a part of that. So Bruce, thank you for being a partner with the college on this and other activities, and I'll turn the floor over to you.
Good evening. I am, as announced, Bruce Curtis, Chief Administrator of the Community Justice Center, and on behalf of our North Island College partners on the Campagnolo Lectures Advisory Committee, first one is Gregory Cran, who's Dean of Business, Fine Arts, Humanities, Social Sciences, Tourism, and maybe some more things. Paul White, who's an instructor in the criminology program, and Jerry Bemister, who's also an instructor in the criminology program. And the reason she's not here tonight is because she is currently advising the opposition caucus as a member of the Premier's Blue Ribbon panel on crime reduction. So that's quite an honor for North Island College to have one of its instructors selected for this provincial responsibility. In any event, we welcome you to the third annual Iona Campagnolo Lecture in Restorative Justice. By way of a little background, these lectures were established by the Community Justice Center in partnership with North Island College, and for our part, it was to honor the life and the work of our patron, the Honourable Iona Campagnolo, the 27th Lieutenant Governor of the Province of British Columbia and the first woman to hold that office. We established this lectureship and presented it as a legacy gift to her on her 80th birthday, when she also agreed to stand and serve as a second term as our patron. She is a remarkable woman with a fighting spirit for defending human rights, advancing the roles of women in society, supporting the pursuits and rights to title for First Nations, and reconciliation with the colonizing society, and serves as our ambassador of restorative justice. These are her passions. She brings a sense of grace and dignity and strength to her role as our patron. She deeply regrets that she cannot be with us this evening due to a recent spinal injury which placed her in hospital and now in a lengthy stay in a rehabilitation center. Her spirit is strong, and she's making a remarkable recovery. She extends her congratulations on Judge Green's selection as the third Campagnolo Lecturer and looks forward to a full report from us on how it went. And I should also let you know that she has 2 other spies in the audience tonight who are commissioned also to report on how it went this evening. She has also asked that we extend her deep appreciation for your attendance and participation and interest in restorative justice. For its part, North Island College joined us as a partner in this project, seeing it as a means of highlighting their criminology program. As we explored the work of the program and the ways in which the annual Campagnolo Lecture could support other objectives, it became clear that restorative justice extends well beyond the university program in criminology. It is an element of the university transfer programs in nursing, in sociology, in business, as well as the diploma programs in human services. It also has deep and profound connections with fine arts and media programs. Most importantly, though, this annual lectureship is part of a significant outreach and public education objective for both North Island College and the Community Justice Center. So to introduce our speaker for this evening, I call on the President of the Community Justice Center, Charles Allen.
Good evening, and I too welcome you to this evening's presentation in honor of Iona Campagnolo. My name is Charles Allen, and I'm the current president of the Community Justice Center. And it is my privilege to introduce to you tonight the Honourable Judge Green, a judge of the Saskatchewan Provincial Court sitting in Yorkton. After being admitted to the Law Society of Saskatchewan in 1986, His Honour was in private practice for 2 years and subsequently practiced with the Saskatchewan Legal Aid Commission, first in Prince Albert and then in Melfort. In 1995, he received an LLM degree with the University of Manitoba. He is the author of 2 books. The first, Justice in Aboriginal Communities, Sentencing Alternatives, which was published in 1998. This book was nominated for a Saskatchewan Book Award. The second, he co-authored with Kearney Healy, called Tough on Kids, Rethinking Approaches to Youth Justice, was published in 2003. Before his appointment to the Provincial Court, Judge Green was awarded the Manitoba Law Journal Prize for his article on circle sentencing in Manitoba and Saskatchewan, and was qualified as an expert in community sentencing in the Saskatchewan Court of Queen's Bench in R versus Carrot. He has written and spoken on justice topics in both provincial and national forums, and was named as a leading edge and world contributor to the field of restorative justice by Prison Fellowship International in 2001. He has lectured on criminal law sentencing at the Law Society of Saskatchewan Bar Admission course between 1993 and 2003. As well, before becoming a judge and in his time away from work, Judge Green wrote a number of reflections on everyday life. His work was published in Briar Patch Magazine, The Lawyer's Weekly, and other newspapers within Saskatchewan. He also presented reflections on CBC's national programs First Person, Singular, This Morning with Michael Enright, Out Front, and Tapestry, and has been a frequent contributor to CBC Saskatchewan. He was appointed as Queen's Counsel in 2002 and to the Provincial Court in Yorkton in March 2004. He is co-editor of the Provincial Judges Journal, a national publication of the Canadian Association of Provincial Court Judges. He is the Provincial Court representative to the Judges Counseling Program, and as well is a member of the Board of Directors of Lawyers Concerns for Lawyers, a self-help organization for lawyers across Saskatchewan. In addition, he's been involved in national judicial education, including the new Judges Education Program in Quebec and a National Judicial Institute Conference. Please join me in welcoming His Honourable Judge Green.
Well, I'm honored and I must say I'm humbled to be here in the Comox Valley for the first time in my life. It was a wonderful supper that was given to me, and I can only say thank you to everyone involved. I also thank Mr. Allen for the kind introduction, which I actually wrote because Bruce asked me to send a biography, so I sent it. The Honourable Iona Campagnolo spoke at my graduation from the College of Law in Saskatchewan in 1985, and it was just a wonderful evening. She was funny, engaging, disarming, And I can't say how disappointed I am that she couldn't be here tonight. But she was just a wonderful person. And it is truly an honor to her that this lecture has been named, has been given her name. Now, I must say, last November was a rather strange day when I looked into my basket and saw a letter from a fellow named Bruce Curtis. And initially, I was looking at it in the Community Justice Center, Comox, and I was wondering, I wonder if he got the wrong person. And then I started to read, and it did appear that he was trying to get a hold of me. I wondered, what would ever lead him to write to me, and afterwards talking to him, he indicated that he had started reading the book Tough on Kids lying on a beach in the Charlotte Islands. So, Bruce, that's a memory I'll always hold with me. Now, again, I started thinking, what could you kind and gracious people possibly want to hear from an aging baby boomer like me from the prairies? And I did spend quite a bit of time thinking about that. But just by way of introduction, Mr. Ellen told you some things about me. One thing he didn't tell you about, however, is that I'm quite a sports fanatic. And I guess one thing I would say is that having been involved in the justice system for years, the one thing you have to realize is that there's a lot of emotion in courts. People are angry, they're upset, they're scared. There's a lot of emotions that come together. And I would argue that a sense of humor is a very important thing to have if you're going to be involved in the justice system. Is that supposed to go forward?
See if I can make it so.
Well, I used to be a member of Toastmasters, so perhaps I can ad-lib. What I'm going to say is that my family doesn't believe I have a sense of humor, but this next slide will show that I do. There, okay. So just to make the case, contrary to what my family says about me, that I do have a sense of humor, here I am this January in Yorkton as a member of a senior men's basketball team playing the Saskatchewan Roughriders on the Grey Cup tour. So they came through Yorkton. And just to show you that my teammates also have a sense of humor, they assigned me to cover one Corey Sheets, who was the most valuable player in the Grey Cup game last November. And here he was showing that he too has a sense of humor as he was laughing at us and continued to trash talk us for the whole game. So, I really don't claim to have a lot of answers for you today, but I will talk to you about how I came to be involved with restorative justice and raise some issues surrounding restorative justice and restorative practices, which I think are key to finding a place for restorative justice in 2014. The really most important part, I think, of me being here today, in my eyes, is to learn from you people and to hear your comments when I'm done. And I think there should be a really interesting discussion after I'm through my presentation. So what will I talk about today? I'll talk about what I mean by restorative justice, my experiences with restorative justice from 3 points of view, as a student, as a lawyer, and as a judge. I'll talk about what I think victims, offenders, and local community members want in a restorative process. I'll talk about restorative justice from today onwards and the values that I think will make it an important part of the justice system and the sort of cross-cultural system, as Bruce alluded to in his comments. And I'll ask a few questions or raise a few questions with you about the future of restorative justice in your own community, and then, as I've said, we'll look forward to a time for discussion. So what do I mean by restorative justice, which is also goes by the name sometimes of community justice? And I would say at the outset that there really is no one definition. In the book Tough on Kids, we quoted from the Church Council on Justice and Corrections in saying that restorative justice is the name given to a wide range of emerging justice approaches that aim for more healing and satisfied approaches to crime. While each approach is different, these processes give active participation to those directly involved or affected. Then in the book, Justice in Aboriginal Communities, I described the process as one that seeks to restore harmony between the offender, the victim, and the community after a transgression. So by whatever definition you use, and you may all have your own definition, hopefully restorative justice includes both the procedure used and the result of the process. Now, while I've said that there really is no one definition for restorative justice, and while each of you, based on your own involvement, may have your own definition, I think an important part of what I mean by restorative justice includes not just what process we use and what result we achieve, but where it takes place, both inside and outside of the court system. And I spent quite a bit of time talking to Bruce today about the work done at the Community Justice Center. And I think I now understand a lot of the work being done here that is completely outside of the court system. A key goal of restorative justice, in my view, is keeping both adults and youth out of the court system. So just after I started with legal aid in Melfort, I was assigned to the Carrot River Court Point. And we went out there, I think it was my first day in Carrot River, and there were 3 little girls from the Red Earth First Nation, which is near Carrot River. And it's just a story to highlight the importance of keeping youth out of the system. I remember these little girls were charged with break, enter, and theft, which is it is a serious charge. And I remember they were about this tall. They were scared to be there. I talked to them, and it turns out that they had done a break and enter, but it was actually jimmying the door in the band office Saturday night. They were bored, they had nothing to do. They went in, they found a Sesame Street tape, put it in the machine, and they did steal something. They stole cookies. And that was the break, enter, and theft. And now, in today's terms, I'm sure that that would be used by alternate measures. In 2014, I'm sure that wouldn't come before the court, but it did back then in 1990. So that was one story. I didn't ever see any of those little girls again. They came and went through the court system. But there was another story about little boys of the same age from the James Smith First Nation, the other side of Melfort. And it didn't have quite as happy an ending, because these 3 little guys were the same height. They had a similar experience one Saturday night at James Smith. They had nothing to do. They jimmied the door in the high school, and they went into the gym, and they started playing basketball. So they got charged with break, enter, and commit mischief by interfering with the lawful use of property. The thing that's different in that story is that I represented each 3 of those young guys as they went through the court system. And just before I got appointed to the bench, the one fellow was off to the penitentiary on a major charge. And I always wondered, you know, we have the little girls from Red Earth and the little boys from James Smith, you know, perhaps I wonder if those little boys from James Smith, if they hadn't been charged, if they'd been dealt with outside of the court by an organization like the Community Justice Center, whether there might have been a different result, because what I've found over and over again is that youth get involved in the system and often they don't get out. They just go around in a cycle, and it keeps getting more and more serious. So that's the story about the little girls from Red Earth and the little boys from James Smith. And I have spoken at many different meetings and explained all sorts of theories and given all sorts of, talked about different sections and about criminal law. And I swear no one has remembered a single word I've said, but they remembered the little girls from Red Earth and the little boys from James Smith. And I think it says something about how we talk about justice and how we teach about justice, because stories are something that we remember, and it's something I think we hold close to our heart. So I guess the first thing I want to say to you is that your stories are very important. And all of the people involved in the Community Justice Center, I'm sure that you have many stories of your own. So I said that I was going to talk about restorative justice through different vantage points. The first vantage point is through my eyes as a student. In 1994, I spent a year at the University of Manitoba, and it was just after the decision in R versus Moses by Judge Barry Stewart, who I understand was here last year speaking to you. And it was at a time when rural and northern courts in Manitoba and Saskatchewan were trying out different restorative processes, including circle sentencing, involving offenders, victims, and local community members participating in sentencing. My study focused on local communities' participation in sentencing and mediation in 6 different Aboriginal communities of Manitoba and Saskatchewan. And the study did show a number of results from community participation. Most common was a sense of empowerment and community building that came with participation in the system that the people in those communities had previously felt estranged from and foreign to. There is no one way or model in which the community became involved in my study within these different communities. Yet, while each of these places had a justice committee, in Wewisi-Kapo and Matthias-Colombe, each had an elder sentencing panel where elders sat with the judge and made recommendations on sentence. And this is a picture I took in Matthias-Colombe, the 2 elders sitting with Judge Martin and assisting him with his deliberations on sentence. Hollerwater, Manitoba had a holistic treatment center, and in the context of a detailed protocol with the prosecution branch, the community and the court participated in a number of sentencing circles on historic sexual assault cases. And this is, Hollerwater is something that Rupert Ross has written quite a lot about, if anyone has read about, done reading in restorative justice. And this was the picture that was published in the Winnipeg Free Press of a sentencing circle held there with Justice Murray Sinclair, then Judge Murray Sinclair presiding. In Sandy Bay, Saskatchewan, their Justice Committee sat with Judge Fafard in a number of sentencing circles. Just sort of as an aside, it was also Judge Ross Moxley, who I understand lives in this area now. He was one of the first judges to do that in La Ronge. And in Sandy Bay, their Justice Committee made recommendations on what an appropriate sentencing could be and how they could be involved in sentencing the offenders. So this was a picture that I took in Sandy Bay Court, which is in the basement of the Roman Catholic Church in Sandy Bay. And it's actually a picture that, I'm not sure that Judge Fafard ever said I could take this picture, but I was there and I was a graduate student, you know, and I just went for it. And he never, after he saw me take it, he just sort of looked away. So, but that gives you some idea of the logistics. Judge Fafard's in the background, and this was a sentencing circle. Next, in Pelican Narrows, Saskatchewan, the judge referred cases to their Justice Committee, who held circles with the offender and the victim away from court and returned to court with a recommendation for the judge. And lastly, in Cumberland House, their Justice Committee did mediations with offenders and victims away from the court in what now would be termed alternate measures or alternative measures or extrajudicial measures. And this was a picture of what they called their sentencing circle committee. They also came to court and provided recommendations to the judge. So then after my year at the University of Manitoba, I went back to being a legal aid lawyer in Melfort. And maybe I'll talk just a bit about restorative justice through the eyes of a lawyer. I think there are a few lawyers in the crowd, but I think those that are here would know that most people appearing in court say that they're sorry. And certainly almost all of my clients did. But some were really sorry, and there was always the issue about who was genuinely sorry, who really wanted to make amends. And I could see in dealing with some of these people, they really wanted to change. And at the same time, many of the people in the rural communities, Aboriginal communities around Melfort, viewed the justice system in a negative light. They viewed the justice system as taking away their young people to jail and returning them in a more damaged and angry condition. And that left a restorative approach, like circle sentencing, as an attractive way for searching for alternatives for their young people. I guess I just sort of as an aside, when I talk about young people, I think that's one of the issues in restorative justice, because when I do court, for example, it seems like a long time ago, but yesterday I was doing court in Broadview. There were young people, but they were all young people. The adults were between the ages of 18 and 22. The children, the youths were technically between 12 and 17, but they're really all young people that are in the court. And I don't know if that's something that people from the outside would see a lot of. So that was really a focus of what was happening for me as a lawyer, was this need to keep their young people out of custody, to keep them in the community, and to keep them doing constructive things and to help them. So I was involved in a number of sentencing circles as a lawyer with different clients. Just as an example of some of the cases, there was a woman that I represented from a First Nation near Tisdale who had no criminal record. She stole thousands of dollars from the band, largely as an advance, but it was a theft legally. And that was one case that we did in the extended sentencing circle. There was also a young fellow, Métis fellow from Nipawin, who had no criminal record for violence, and on the day he lost the custody of his child, in a fit of anger, went out and assaulted an elderly man on the street in Nipawin who he didn't even know. He'd never done anything like that in his life, and it just really shocked the community. In both of those cases, there was a real interest in the community in trying to figure out what happened. It certainly went far beyond what the police were saying. There was just a widespread interest in trying to find out what had happened, and in particular in the Nipawin case, that the family of the elderly man were just really wanted to meet the offender and try to answer for them why this had happened. There was one other case that we dealt with in an extended sentencing circle. It was what we came to refer to as the golfing match case. It was happened at the Red Earth First Nation, where two families were having a party. It was before a wedding, a party from one First Nation marrying a party from the other, and there was a golf bag at the party, and it ended up, the fight started, and the golf clubs became the weapons of choice. And the interesting thing about that case was that almost everyone there was charged with aggravated assault, but they were also victims, so that the fellow that was charged with aggravated assault was also a victim in another assault. So we had a situation where most of the people charged had no criminal record, and they were looking at losing a major part of their population going to jail if we didn't come up with some alternative. So that was a case where there was a community outcry, there were resources to try to make it happen, and back in 1998, that ended up in conditional sentences for all those people. So these were the questions, just going to turn around here, that went through my mind as a lawyer around when we would look at a restorative process. Who is really sorry and who wants to change? What are the appropriate cases for a restorative approach? And I think perhaps most important, what are the community and justice system dynamics that will let it happen? So that was sort of the initial part after I came back from my LLM studies, and then I met a fellow named Carney Healy from Legal Aid in Saskatoon, and my life really changed. And I became increasingly involved in youth court and youth issues. And out of that partnership with Carney came the book, Tough on Kids, Rethinking Approaches to Youth Justice. It's a bit of a misnomer because it's referred to tough on kids, and it almost sounds like we're talking about a punitive approach where we're talking about the exact opposite. We said a lot of things in the book, and I guess Bruce read it when he was on the beach there in the Charlotte Islands. But I think fundamentally there was one thing at the front of it all that we were saying was that we need to consider that despite the similarities to the adult system, the youth system is different. That young people are developing psychologically, emotionally, and physically, and we need to take that into consideration in the way we treat them. And at the end of the day, if we don't have hope for our young people, who do we have hope for? So that was really where we started from, and there's a lot of different discussion in the book, which is a bit of a polemic in some ways, and going at a lot of different issues. We don't really have time to talk about a lot of them tonight, but I just wanted to mention three that we talked about in the book. The first being the causes of crime and what brings young people to court. And in particular, whether factors like fetal alcohol spectrum disorder might be the reason that a young person is coming to court. Certainly, when I look at a restorative process, I think trying to understand what has brought the young person to court goes a long way in trying to come up with some sort of plan about how that young person will stay out of trouble. And indeed, I think it also helps in trying to look at how the young person can make amends with the victim. Fetal alcohol spectrum disorder has become a major focus in our court in Saskatchewan. Our chief judge led an initiative with discussions with the broader community about the disorder. And there was a conference in Edmonton last September that some of you may know about, which was an international conference which produced just recently an international charter on the prevention of FASD. So that was really a first focus in the book, was what is bringing the young people to court, trying to understand that. Second focus, major focus in the book, was the circumstances of Aboriginal youth and how these may differ from the broader population. It's certainly a major issue in Saskatchewan, I know in Manitoba. The young people that I deal with are predominantly from the Aboriginal communities around Yorkton. So it's the whole section in the book about trying to look at those unique circumstances. Then we have a whole section, too, on the encouraging effects of finding a positive mentor or role model for a young person. And we said that in trying to recognize the importance of providing such a person to a young person. Self-esteem is a huge issue for a lot of kids that end up in court, even those that try to act tough and look like they don't care. But I think you'll find low self-esteem to be prevalent in so many of the young people. So about 10 years ago, I got the call from the Minister of Justice, and my life did change in a lot of ways. I think as a defense lawyer, my life was fairly straightforward in the sense that I knew what to say. I wanted to keep my clients out of jail or young people out of custody. And I had a certain line that I used and a focus. And then I became a judge and I started hearing all these voices from all these different sides. But the one thing I want to tell you about is very early on, about the second week I was a judge, I got an email from one Barry Stewart, then recently retired from the Yukon Territorial Court. And the one thing he said to me was, never stop building bridges. And it was really an interesting thing for him to say, because I thought he was going to talk about the importance of the independence of the judiciary and all sorts of platitudes, but it was just very straight, never stop building bridges. And in my view, there is a delicate balance between the independence of the judiciary on the one hand, and there are things I do where I have to be independent, but on the other hand, it's essential to to have a respect for the contribution of other players in the system, and to understand that at many levels we do work together. So people tend to look at judges and think that we have all this unbounded power, but actually the powers of judges are all, the powers of a provincial court judge are all statutorily determined. There's a case from Saskatchewan by Judge Mary Ellen Trapelafond, who I believe is now your representative for youth and children. Children and youth, sorry. And what she did in that case was that it involved a child with fetal alcohol spectrum disorder, and she had ordered that the young person be on probation and be supervised by a youth worker that was trained in FASD. And that was overturned on appeal because judges don't have the right to order the spending of money. We don't have the right to order another arm of government to do something in a certain way. So when you first hear that story, you think, oh, come on, that can't be. But that is true. We can only pick from certain alternatives that were given in the statute. All that said, I think that there are a number of sections, both in the Criminal Code and the Youth Criminal Justice Act, that leave open options for restorative practices. And just here we have Section 718 includes the following objectives of sentencing: to provide for reparations for harm done to victims or to the community, to promote a sense of responsibility in offenders and an acknowledgement of the harm done to victims and to the community, and to assist in rehabilitating offenders. Then Section 718.2 sub E is the so-called Gladue clause, and it says that the courts to consider all available sanctions other than imprisonment that are reasonable in the circumstances, with particular attention to the circumstances of Aboriginal offenders. Further, in the Criminal Code, the Section 723 sub 3 allows the judge in sentencing to require the production of evidence that would assist in determining a fit sentence. And I've often done this in court in Kamsack. If the Justice Committee is there, if they want to say something on behalf of someone who's being sentenced, if they want to make some representations, I'm quite prepared to hear that. So there is that discretion for the judge. Section 717 allows for alternative measures for adults. And one section that I didn't note here that I forgot to note was Section 722, which is the victim impact statement, which allows the victim to come to court and give a statement either in writing or orally. So then going on to the Youth Criminal Justice Act, Section 19 provides that a judge, youth worker, or police officer can convene a conference to give advice on extrajudicial measures, conditions for bail, appropriate sentence, or a reintegration plan for youth. Section 18 sets out the whole parameters around youth justice committees. Then the youth Gladue clause is in Section 38 sub 2 sub D, similar to the adult ones, which includes looking at all reasonable alternatives to custody with particular attention to the circumstances of Aboriginal young people. And finally, Section 42 of that Act talks about personal service, and that's something that we have used quite a bit in a restorative vein in looking at whether the young person who's wronged the adult might do personal service for that victim. I was looking at the Community Justice Center website before I came here, trying to figure out who you were. And there's one story there about some boys that damaged a flower bed and ended up going back and doing work for that victim, and it certainly reminded me of that section. In just speaking through the eyes of a judge here, in looking at an emphasis on healing and therapeutic approaches to justice, and I think that that's key to restorative justice, I would argue that there's evidence of a movement towards problem solving and therapeutic justice in Canada's courtrooms. And I don't claim to be an expert on what's happening in BC, but But I can tell you in Saskatchewan that we have 3 domestic violence courts, 2 drug treatment courts, 2 mental health dockets. And in each of these courts, the judge, together with appropriate support workers, seek to identify the underlying causes of criminal behavior and to apply a therapeutic model, as opposed to a punitive model, towards correcting the behavior of the offender. As well, just as an example of what's happening through the Canadian Association of Provincial Court Judges, in 2011 we had our conference in Regina on the theme of restorative justice. And the upcoming edition of the Provincial Judges Journal, of which I am co-editor, is on the topic of problem solving and therapeutic approaches to justice in Canada's courtrooms. And what we're going to do is look at the approaches in all the provinces and territories. So we're really looking forward to that, and I'm waiting to get the contribution from BC, because Bruce was telling me today of some of the interesting things that are happening in this province. So what do victims want in a restorative process? I don't think there's really any one answer to this. If you've ever heard Rupert Ross speak, that's the first thing he says right off the bat, is that victims want different things and there can be no expectation of a victim. I just want to tell you quickly about one case I was involved, a restorative case I was involved with. It was a conference for a young person in Yorkton. And what happened in that case was, I describe it as the every parent's nightmare case. Parents had gone away for the weekend. Their 17-year-old daughter had a party. And it was a small party. There were only about 8 people invited. There was no problem there. The problem was that 100 drunken people crashed the party. So the RCMP in Yorkton get a call. They go to the party. The 2 officers get out. The first one gets hit in the head with the beer bottle, and it just goes downhill from there. The girl who was having the party ended up getting charged with obstruction. She wasn't charged with throwing the beer bottle, but she got involved, and I think she was involved trying to tell the police what had happened. But in any event, it wound up that the officer was quite content to do this as a conference and to leave it at that. But he wanted to tell the young person what had happened to them on that night and what it was like for them. And he described going to a stabbing and all the things that had happened to them that night, and then getting this call and coming and getting out, and his partner getting hit in the head with a beer bottle. After he was done, then the girl, who was in tears, because for her to be charged, it was just like the end of the world. She told him what it was like for her, having her party, have the parents go away, she's in charge of the house, the party gets crashed. And at the end of it, the officer just said, "That's it. I don't want anything more to happen to her." And the Crown ended up withdrawing the charge. But he just wanted to tell her. He just wanted to be heard. So what do victims want? Victims want different things. But I think you might be surprised if you saw some of the pre-sentence reports that I see in court, and you might expect there to be somewhat of a cynicism among victims, sort of lashing out at young people. It's really not what I see. More often than not, the victims, especially people that are a bit older in age, say that they want to help the young person. They want to see that the young person is helped, and that's often the first thing that's mentioned. So what do offenders want in a restorative process? There's certainly an enormous discretion in the criminal law for who gets charged. I don't know how many clients that I represented were charged with mischief by interfering with the lawful use of property, where they would just, really innocent circumstances to start with. They get invited to a party, they're there's a fight breaks out, they're not in the fight, but somehow they get charged. And just to understand that, there's a lot of discretion there. One of the themes that Carney and I brought up in the Tough on Kids book, and I don't know what you'll think about this, but we argued that everyone's an offender in a sense. When you look at that type of discretion, looking both at the criminal law, other statutory law. Now, I'm not going to tell you what I did as a kid, but there is a huge discretion, and a lot of times people end up in court and they don't You know, it's almost like a deer caught in the headlights. It just happens so quickly. So what do offenders want in a restorative process? The guy that I talked to you about from Nipawin, he said to me, I did a terrible thing, but I'm not a terrible person. I want them to understand that I'm not a terrible person. And it brings the whole spectrum, it brings up the whole spectrum of good people doing bad things. And that's certainly what I found representing people, that they were admitting they'd done a bad thing, but they just wanted other people to understand that they weren't all bad and that they were trying to make reparations. So really, I guess the most important part of what I have to talk about, I think, to you people is why is restorative justice important to local communities like Comox and Courtenay? And how do we work together? Back in 2000, I spoke at a meeting in Saskatoon that was organized by the Federation of Saskatchewan Indian Nations. And at that meeting, Chief Justice Beda from our Court of Appeal spoke. And one of the things that he said was that it was a great frustration to him that by the time he saw a young person in court, that person had fallen through all the other systems in the community that really should have caught the young person. You know, he said that by the time we see them, it means that their family, their school, other supports, including social services and health, have not been able to provide for the need and challenges of that young person. And that, in his view, meant that the court is left to come up with a solution that the closest to the youth, and I would suggest perhaps the people in the best position to help the youth were unable to come up with. And I would suggest to you that the community may be best equipped to help those young people, and that restorative processes may be a way to see that happens. We talk at length, and I was going to say ad nauseum, but at length in Tough on Kids about the importance of interdisciplinary approaches to justice. And by that, we were referring to the importance of coordination and cooperation between the organizations and agencies and community members that can help offenders and victims. Now, I expect that there are a number of people here that work in different government organizations, and I expect that most of you have a sense that you're overwhelmed, that you're being asked to do too much. One of the themes that we talked about in our book was the sense that the justice system is the default system, that when a young person falls through all the cracks in society, they end up in court before the judge, and that the justice system becomes the default system. I was at a restorative justice meeting in Halifax back in 2002, and we were having a circle discussion about this whole issue, and I went through my little shtick about that and saying how I thought the justice system was the default system. The fellow to my right was in charge of healthcare funding for one of the maritime provinces, and he was just absolutely irate, and he was just in my face, and he was saying, like, we're the default system. The health system's the default system. We catch everyone when they fall. And I thought to myself, you know, if there was a teacher there, what would they be saying? I'm sure they would be saying it's the education system. We're the one that catches them when they fall. So I think that sense of being overwhelmed and set upon is something that you find. But at the same time, I think we need to build bridges between people and not divide them. And finding a way to do that through restorative processes, I think, is one very constructive way to try to bridge that. I wanted to say that an organization like the Community Justice Center is, in my view, very important. And one of the things I think it does is provide context for the people about restorative justice and restorative processes. And maybe if I could just give one really quick example in my own life about context in the justice system. For years in Yorkton, there was a reporter that came and wrote stories about us that were quite critical. And basically what we had was the charge and then the result, you know, and no context about what had happened and how we got to that result. Then after some point, there was another reporter that came. I believe he actually came from BC. And he did some really interesting things where he would come to court and he would write not just about what the charge was and what the result was, but what the context was and what was happening with this person that was in court and explaining what happened. And I remember one day I talked this young fellow out of pleading guilty on a 08. It sounded like I was a hero when I read the newspaper article, but it was just he was giving the context about what had happened in that person's life and trying to explain it. And it strikes me that an organization like the Community Justice Center is one that can provide context and education about restorative processes to people so they understand what's happening. And I appreciate that there are a lot of confidentiality issues around it, but the example of the story on your website, I think, is a good example of trying to give some context to what happens in a restorative process. So why do I think restorative justice will move forward from this day onwards, both inside and outside of the court? These are some of the values, and I think there are probably other values, but people have different ways of defining justice. I think you all probably have a way. I would suggest that fairness is key to justice, and I think that a restorative process is a fair process when you have all the parties involved and participating and having an equal say in it. Respect. One of the things that Carney and I tried to get at in our book was the whole issue of us versus them. And it's something that I see quite a bit of. If you come away with the view that it's the good people versus the bad people, I think we're in a lot of trouble. And I think that one of the ways that you get away from that type of approach is by talking to each other. And I think that a restorative process does show respect when people can talk directly to one another. Truth. There are some very difficult discussions that are had in a restorative process, but they can happen in that forum. And hope. Certainly, I think there's hope in a process that seeks to restore torn relationships. And at the end of the day, perhaps we are all guided by our beliefs in human nature. One of the interesting things that happened to me as a lawyer was I went to a conference once, and I always had this view that I represented people that were lost sheep, and I was trying to help them. And again, these were good people doing bad things. There was a fellow that I got bunked with out at UBC, and he was a criminal lawyer from downtown Toronto. And I gave him that little theory of life, and he just looked at me like I was crazy. He said, no, I represent criminals. And that's the way I look at it, you know. And I just couldn't believe that he would say that, but I think it underlies that the way that we look at human nature does affect the way we look at the justice system and what we think the justice system can do. In my view, there are no throwaways. There are good people doing bad things, and they do need help, but there is a way that can be provided. Engagement was one of the other values I had here. Had kind of an interesting discussion with Bruce at supper, which might have changed my mind on this a bit. I think that something magical happens when people talk face to face, person to person, and I don't think it happens on the phone, and I sure don't think it happens when you text each other, as I'm there texting my son to come for supper. You know, I mean, it's crazy. I think there is something that happens, and I think it happens in the way people build trust when they're together and when they talk. So I think engagement is a very important part of what happens in a restorative process. So the most important thing, and the reason that I'm quite certain that in a community like this your restorative processes will continue, is that there are people like you who are prepared to make a difference. And I expect, I didn't know any of you before I came here today, but I expect that most of you are idealists, that your involvement in the Community Justice Center or Justice Matters was likely because you wanted to make a difference in someone's life, in either the victims or offenders or the community at large. And if you'll just indulge me for a minute, because I can't do anything like this anymore. This was a piece that I did for CBC Saskatchewan back when I could do things like that. And I also published it in the Lawyers Weekly, and it's called Making a Difference. So this is said in your honor. While attending law school, I had visions of making a difference. I dreamed of being a valiant crusader for the underprivileged, righting the wrongs of society. I still have that dream, although now not as often. Shortly after beginning my time with legal aid, I was assigned the Nipawin Court area for court. One of my clients still stands out in my mind. She had a terrific alcohol problem, a terrible alcohol problem, and almost always came to court under the influence. She was also extremely bright and was faster off the draw drunk than most people, including me, were sober. She would stagger into court 15 minutes late and then signal wildly to me before proceeding with some lengthy explanation about why her case should be adjourned or why the police had it wrong. One day I was busy as usual, racing around the courtroom speaking with my clients. In she staggered and gave me her characteristic look, demanding my attendance. She was especially distraught as I approached her. In slurred speech, with a look of complete sincerity, she said simply, "Mr. Green, your fly is undone." What a defining moment in my legal career. Despite that embarrassing memory, I've long wondered whether any of my efforts have made a difference, or is my contribution best described as a spectacle? I expect that deep down we all would appreciate some quiet confirmation of having made a difference for the poor and needy in this troubled world. A friend of mine once described her teenage intention of changing the world. At 18 years of age, she had definite plans on how she would correct many of the world's injustices. But then she married and had children, and looking back, she realized that she had not changed the world as planned. This happens to a lot of us, sincere plans of building a better world and correcting the forest of injustices we see. A professor speaking at a conference I attended summed it up concisely. The reality, he said, is that we end up dealing with individual trees and not forests, trying to make some small difference in the lives of a few troubled people. A former co-worker many years back described to me her philosophy of life. She said, throw a rock into a still pond and you immediately see rings forming out after that splash. Wait 5 minutes and the pond is now completely still. That's the total effect of your big effort. It was a startling, if pessimistic, view of our lives. But let us always remind ourselves that even if the most we accomplish is a few rings in the pond, it is still worthwhile. Making a difference to even one person in need does matter, whether or not you forget to do up your fly. So just briefly, I said that I would have some questions for you people about the future of restorative justice in your community. And again, I don't think I have any answers to these, but I'll just go through them. What sort of offenses, offenders, victims, and also disputes can be dealt with in a restorative process in your community? What are the resources, lay people, money, government, and non-governmental organizations that are accessible to support restorative processes in your community? To what extent are local community members willing to participate in and take responsibility for the restoration of disputes? And Bruce today told me that you have 150 volunteers at the Community Justice Center, and I think that's remarkable. And last, again, returning to the same theme, are we prepared to move away from an us versus them mentality in thinking about the restoration of disputes? So in closing, I think Mr. Ellen said at the opening that I don't know if you said this, I wrote it in that I live in Yorkton with my wife and my border collie. I don't remember. So it struck me when I was preparing this that a lot of things happen in court where people are acting out, they're yelling, people are upset, and I always have this line which is take a deep breath, just take a minute. You know, quite frankly, it works sometimes, a lot of times it doesn't work at all. This is Sasha, this is our border collie, and she has the most calming face in the world, and she wraps us around her paw and does all those things. But it struck me that maybe I should change my strategy a bit. Perhaps rather than telling people to take a deep breath, if I show them this picture, it might have some positive effect on them. So I want to thank you again. I didn't ever think I would be in this part of the world. I'm here. I'm delighted to be here. Thank you for the supper. Thank you for the introduction. And keep telling your stories. So I think we're going to this isn't necessarily a question period, it's a discussion period too. I've done a lot of presentations to classes and I always say, you know, this is your chance, you know, go for it. So.
Hi, I'm Doug Hillian. I worked in the court system for a lot of years and appreciate both your insights and your stories. I've been both discouraged and filled with hope about the growth of restorative justice. Filled with hope because of all the good things that I've seen happen, and discouraged that the system has been so slow to embrace it in any sort of widespread attempt. And I spoke to the former Attorney General of the province, Wally Opal, who had the view that I think a lot of people in the formal system have, that it's fine for minor offenses as a prelude to more serious action, but not really something that should be incorporated into the mainstream of the system. And I've always felt, as you've demonstrated with some of your slides, that it's not a matter of either or, it's a matter of and with. And we can have sanctions and sentences through the court, and we can also incorporate restorative processes into that. But I'm just curious about what your take is on why the formal system is so slow to actually embrace more restorative practices that could make so much difference to people who, as you said, want to know why this happened, want some direct engagement with each other, and yet we perpetuate this system that keeps people in separate corners, unable to actually speak to each other.
Well, I think it's a very good observation. The R versus Moses case itself was fairly serious. And when you look at what his record was and the background, there's a case in Saskatchewan, R versus Joseunen, which was often cited, was Judge Fafard's case, where he was making a similar point. There was a very serious stabbing, and it was a situation where there wasn't going to be a community-based sentence, but he made the point that there could still be a sentencing circle, and there could still be considerations of the things that you've mentioned. It is true, I think, that a lot of the restorative justice initiatives are personality-driven. You know, that you get either a judge, doesn't have to be a judge, can be a different person in the community that really drives it, and until it becomes institutionalized, it doesn't have sort of a lasting effect. I think it's still important that a lot of cases not be dealt with in court. You know, I mean, we've got two things happening, and what you're talking about is one end of the spectrum, and then there's the other end too that I don't think we want to lose sight of. I think it's still very important. In BC, I understand that you have a lot of pre-charge alternate measures, which you wouldn't see very much of in Saskatchewan. Okay.
It always appeared to me that in restorative justice there are three elements. There has to be the offender, the victim, and the community. And all three have to be aware that this is good for each of them. And would you comment on that, that you can deal with almost any crime if, in fact, the community does not want a punitive course to follow. And with children, there are some things like the Olsons and the Schonburns and so on that can never, in my view, be dealt with. But there's an awful lot of other cases, as in Port Hardy, as an example, it was 3 drunks, and one of them stabbed the other almost to death in the drunken fight. The immense amount of remorse and so on with the values of the community itself meant that the sentence was not what would be the standard one had it been in a larger community with different people. And looking at it, if those 3 elements are there, is it possible, in your view, that we can deal with almost anything?
If you have respected people in the community that aren't family members that have status, it's very difficult for me to say that, for me to say what their community wants. I think it's for them to say. So that's a real struggle between the close-knit community versus province. And I don't really have an easy answer for it, but I think you articulated it very well. Hello?
Am I on? Could you tell me exactly how a sentencing circle has evolved and works, and how much does the judge who's participating in it take that into consideration, and how much leeway they might have?
The practical answer on who decides, ultimately, the judge does make a decision about what the appropriate sentence is. So, is it inferior to what you might do in the Community Justice Center, where it's, I don't know exactly what you do, whether it's by consensus where everyone has to be together. I mean, perhaps what you do is superior. It's purer, I guess, because the reality, the judge does make the final decision. That said, if there clearly is a consensus and it's a lawful sentence, that might well be a challenge for the judge.
Thanks very much. I think I'll be expressing my ignorance here about the whole restorative justice system. I was actually on the phone last night with an uncle of mine, and my cousin, his son, was killed in a drunk driving accident on his 19th birthday in 1980. And we were talking about it last night, and it was like it was yesterday for him. And he said that he was not allowed in the courtroom because of how he felt about the offender. There was no forgiveness in his heart. There was no room for him to be in a circle, I don't think. And when earlier the question came up about, how severe of a crime, I guess my question is how do you, the community standard seems almost to be whether or not the victim or the victim's family is willing to engage in the process. Mm-hmm. And I'm just wondering if you can comment on that and give me a little bit of clarity on how it actually can come to be, because we can live in hope, but when you're in those circumstances, it's hard to maybe take that first step.
Yeah. Well, that's a tough one. I think when I talked about victims, what do victims want? They want different things, and they may, as you say, want different things at different times, too. But that's a very difficult example that you gave. I don't think that anyone should be forced into it. If that's your question, no. I don't think. It doesn't sound, just from what you've said, like it would be appropriate. But there are some serious cases that have been dealt with that way. And it relates to the victim's willingness. Well, certainly to be involved with it if they don't want to have anything to do with it. I think, how do you tell a victim how they feel? I don't think you do. So, but.
Hello, my name is Brian Tyke. I was just wondering, because there's such a diversity of restorative justice type programs and alternative forms of justice programs, that there is no doubt a consensus that some programs might lack more credibility than others in their success and the kind of outcome that they have. And I was just wondering, from your experience, you no doubt have a diverse experience with exposure to these different kinds of programs, how you've been able to overcome the barriers when perhaps suggesting to your colleagues in the legal profession to give ground to these kinds of programs and to give the kind of positive gratitude towards them and how their success plays out.
Most of the judges that I know are very receptive to alternatives and to ideas and to options. A lot of the programs are done, in a sense, behind the scenes. You know, like the Community Justice Center is a program that I think if I was a judge in this area, I wouldn't be directly involved with, because they're working out of the system. So the alternative measures organizations are doing their work. We hear about it when it comes back to court, just when charges are withdrawn. But I don't think that there's any hesitation on any of the judges that I know to say that that's very good work being done by those people. I think I gave them my example of different therapeutic courts in Saskatchewan. I think there's a lot of openness to try different things. It's a really tough question, though, because in my experience, you know, I mean, have I sent people to jail? Yes, I have. I mean, there's sometimes it doesn't seem like there is an option, but we're supposed to look at all the options, and especially if there's people from the community that have a plan. Is there a plan for this person? I think there's a lot of openness about that. Now, if we don't have an option, though, that's a different matter. If Parliament changes, you know, with the minimum punishments, if we're not left with an option, that's sort of a different question. But I'm not sure that question in itself affects it says that the restorative process goes out, that the baby goes out with the bathwater. Yeah. Someone up there, Bruce?
Is this, oh, hi, I'm Kirsten. I was just wondering if you had any experience with restorative justice when there was like a power, like a big power differential between victim and offender, or what your experience with that was.
My first book, which was actually my master's thesis that got turned into a book, I talked a lot about power imbalances. I think that's a big issue. But is it something that can be addressed? You know, there can be support people for the victim. It can be considered. The criteria that Judge Fafard came up with for sentencing circles indicated one factor, which was whether if it was a spousal assault case, whether the victim was subject to battered spouses syndrome. So there it was right there. Was there a power imbalance? So I think that is a factor. Can it be addressed? I would think it could. Yesterday in Broadview, I was doing a preliminary inquiry in a sexual assault case where there was the criminal code allows a support worker to come with the complainant. And so I think there's ways of addressing it, but is it a concern? Yes, it is a concern.
Hi. My name's Allison. I'm the FASD key worker in the community. So in your experience, my question is, what is the commitment of restorative justice, the restorative justice process to individuals who reoffend, particularly those who are affected with FASD?
Well, I think, as I said in my presentation, FASD has become a big issue in Saskatchewan in terms of trying to recognize the problem. What are the resources for those people? It is always the issue, and actually you're a person that would probably know a lot more about that than me. I mean, fundamentally, it's not fair, is it, to treat someone who has that sort of cognitive disability the same way that we treat others. They don't understand the consequences the same way. They don't understand what's happening. And it's not fair to impose the same consequences. So that part I think most people would agree on. The supports, though, for those people, like I gave the example of Judge Mary Ellen Trepel-Lafond ordering that the youth worker have training in it, and that didn't stand. So we're always trying to look for a plan that would support the young person and try to help them. But if you're asking me whether there are enough resources, I don't think so. I don't see that. The reason it became such an issue is I think we were missing it. I think we were. You know, youth that can look in every way normal just don't understand what's happening. And they'll tell, you know, do you understand? Yes. It's how you ask the question too, isn't it? So, I mean...
I'm pretty new to the idea of restorative justice, but I was just wondering how broad restorative justice concepts are outside of Aboriginal communities. This is why I came here, to find out about it.
Well, look at the Community Justice Center. Do you mean, is restorative justice happening outside of Aboriginal communities? Yeah. Sorry, I just missed the last thing you said.
How we have information, how we get that information out. Part of the information you're looking for is that in British Columbia there's 150 restorative justice programs working across the province. Mostly they're not terribly well known because they're working in collaboration in a closed system with the RCMP. Cases come in, they get dealt with, and they get closed. The Community Justice Center does a wider range of cases than just RCMP referrals, and we have a public education mandate as part of our mission. Our board of directors is actually very concerned that there be a wider understanding of what restorative justice is, the whole range of places it can be applied, and we actually take referrals from, I think the last count was 22 different referral sources, including the RCMP, but including 21 other sources of referral. So it's pretty widespread, but it takes a long time. It takes a long time to get the information out to people who have an opportunity to refer, and you're constantly beating a rearguard action to do public education. Mostly people are, at the optimal time to learn is when they're facing a problem, and not everybody's facing a problem at the same time. So it's more a one-on-one education plan for doing that.
Well, Bruce, I see it's about 9 o'clock here. Was that when we were supposed to kick me out of here?
Well, we're not going to actually kick you out. We're going to say some nice words, and then we're going to escort you to your limousine.
Thank you. I have the distinct pleasure of thanking our speaker here this evening. My name is Gregory Cran, and I am one of the deans here at the college. I'm particularly impressed that you do describe the justice system as the default system. In many ways, I see the justice system simply decontextualizing who we are to what we have done. And when you say that we need more context, for me that means through story. And that's the stories that get shared, especially within the restorative justice practices. And I'm grateful for you and grateful to everyone for being here tonight. Thank you so much.
Thank you.
Just before you go, I'm also been asked to let you know that the 2015 Iona Campagnolo Lecture Series will honor Chief Justice Beverly McLaughlin from the Supreme Court of Canada. She will be our guest speaker, and if you wish to attend that next year, even though I know it is 12 months away, please sign the list on the outside, noting your email address so we know how to at least keep you informed. Again, thank you all for coming, and thank you.
Thank you.